morning, Your Honor. Ben Lusty on behalf of appellants Paul and John Hardman, who are present in the courtroom this morning.
Good morning, Jonathan Jenkins and Dalton Smuin. On behalf of the appellees, Donna Campbell and Marcia Jacobs.
Very good. Counsel?
Drew Parkinson, Your Honors, on behalf of appellees Heber and Shirley Hardman.
All right, I understand that the appellees are going to split the time exactly in half.
That's right.
Is that right? All right. Just for everybody's notice, we to some extent enforce the clock here, unlike our friends next door who have zero clock discipline. But that's true. But on the other hand, if you're answering questions and you have all zeros, just keep answering the questions. We don't hold that time against you, and on your rebuttal, you'll get your full rebuttal. And if we think, or especially if I think that you're wandering into your rebuttal time, I'll tell you that. So if I don't tell you that, you need not worry about it. Do you have any questions before we proceed today?
No, Your Honor.
Okay, then you may proceed.
Sorry.
That's okay. Well, good morning, and may it please the court, Your Honor. On behalf of appellants, we respectfully ask this court to reverse the decision, the interlocutory decision of the district court denying the appellant's motion to compel arbitration. For ease of reference, I'm going to refer to the parties by the brothers, the sisters, and the parents, just to make things a little easier and not out of undue familiarity or disrespect. In basic general outline, this case involves a property dispute, although that property dispute is framed in the dissolution of an LLC. The LLC agreement had an arbitration clause appended to it. In protest of a proposed distribution, the brothers objected. They sought to dispute the proposed distribution, largely led by the sisters. They sought arbitration prior to filing a complaint. The sisters were not amenable. Consequently, in September of 2021, they filed a complaint with the district court, and the very next day, they filed a motion for a temporary restraining order asking the court to maintain the status quo pending arbitration. That temporary restraining order was temporarily granted. Throughout the pendency of the first TRO, appellants continually sought, at least on 9 occasions from September until November.
Can I ask just one clarification? You said TRO pending arbitration, but that wasn't what the actual language in the motion was, right?
No, Your Honor. On the record, and I believe it's page 14, the requested relief was a stay, a temporary restraining order pending arbitration, specifically referencing that there was
Pending arbitration or pending alternative dispute resolution?
Well, so that raises kind of a preliminary and a tertiary point. The arbitration agreement did have a condition precedent to arbitration that said the parties shall attempt to mediate. That was amongst the requests in the extra litigation communication of counsel. Okay. However, if you look at its section, I believe, I think it's 107 of the Arbitration Act, which says that an arbitrator does have authority to determine conditions precedent prior to an arbitration before that right vests. So I would suggest, Your Honor, that although mediation is a condition precedent, it's still procedurally proper to say pending arbitration, knowing that an arbitrator is going to be the decision maker as to whether the mediation has been done in good faith or been properly done. But getting back to the narrative, the temporary restraining order was then sought to be continued and made into a preliminary injunction, again pending arbitration, at which point the district court determined the factors supporting an injunction and a temporary restraining order were absent, and thus the TRO was dissolved. Within
Is that really what your TRO sought, though? Because it seems that at the very beginning, did your TRO request actually say pending arbitration or pending mediation or pending anything other than a resolution of litigation?
The TRO sought to freeze the status quo and referenced that arbitration, mediation, arbitration, alternative dispute resolution was the ultimate forum through which...
Where's that? I printed out a copy of your ex parte motion for a TRO. Where does it say that about the arbitration?
I believe it's on the first page, on the face of the motion. And I spent more time in the case law, Your Honor, than the record last night, so I don't have the exact citation, but it's in the initial application for the TRO. Now, the brothers recognize that the complaint on its face doesn't say, we believe that we have a right to arbitrate and we're seeking that.
I just found it myself. It's on page 2.
Oh, even earlier in the record, sorry, Your Honor.
I want to go back to what you said happened prior to the complaint. You said before the complaint, the brothers tried to arbitrate?
There was some correspondence with counsel in August prior to the filing of the complaint saying we want to go to the pre-litigation arbitration dispute. I believe that's page 622 and 623 of the record is where that's found. But
To me, that may matter depending on which version of the Arbitration Act is controlling, because the current Arbitration Act says that you initiate arbitration by sending written notice that you want to arbitrate. Is that, would it be your position that you sent written notice that you wanted to arbitrate?
yes, that is what the Arbitration Act says. The Arbitration Act also specifically provides that if the method for selection of arbitration fails, the court can grant provisional remedies.
Right, but the court really can't do that until you've initiated arbitration, is the way I read the current act. So that's why I'm wondering, had you initiated arbitration before you sought provisional remedies?
Potentially. The sisters and the parents, however, refused to cooperate in any selection methods, which is why then the motion to compel arbitration becomes necessary regardless of whether an arbitrator has been selected or not. Now, we can.
And I guess then the other question, before you move on, I'm sorry, is which version of the act do you think is controlling,
The current act,
and why?
certainly. So if we look at ASC, the Wolf Mountain case, if we look at, I believe it was Powell v. Cannon, and even if we look at the parents' brief, everyone says the Arbitration Act's procedural. And the Supreme Court's precedent in State v. Clark said, look, if the statute solely governs the mode, the method, the way you get the substantive remedy, in this case, the right to arbitrate, then it's substantive and you look at the act in effect at the time of the procedural act in place, in this case, the motion to compel arbitration. So the current version of the Arbitration Act would apply, Your Honor. At least that's how we view it.
Even though when the parties had a meeting of the minds, that was not the act in place, when they had a meeting of the minds that we're going to follow Utah arbitration law.
Well, certainly true, although I think that there's some evidence on the record too that there was an amendment to the Arbitration Act, to the LLC agreement in 2021, so that would bring it into execution after. However, if we apply State v. Clark, Powell v. Canton, ASC, Utah, it's a procedural statute. We look to the procedural rules in place at the time of the procedural act. And certainly the key provisions of the now, it may be a different question as to whether you have a valid arbitration agreement, whether the terms of your arbitration agreement are enforceable. I think it's Section 104 has some unwaivable provisions. Those may vary depending on when the arbitration agreement is signed. But with respect to when the demand for arbitration is made, when the motion to compel arbitration is made, if we look at State v. Clark, those are procedural acts, and the Supreme Court was very clear. We don't look at we look at the law, the procedural law in place at the time of the procedural act rather than the substantive facts giving rise to the substantive claim. So at least for all respects that are relevant to this appeal today, I would suggest that the present version of the Arbitration Act applies, or at least, I don't know if the legislature has amended it between now and then, but in 2021, that version should apply. But really the hinge point of this case is whether the district court properly interpreted this court's precedent in Turpin and Educators Mutual. And in those cases, this court decided if you as a plaintiff file a complaint without more, that is evidence of an intent to waive your right to arbitrate. Now, but we have to look at the facts of that case in the language, the facts of those cases in the language of Turpin in particular. So Educators Mutual, we had a complaint, we had a year of litigation, we had a motion for summary judgment, and only then a belated request for arbitration. In Turpin, we had DOPL pre-litigation procedures, we had a complaint, we had a motion to dismiss on the merits that would have been decisive. We had 6 months of litigation, and then we had a belated demand for arbitration. In this case, we had a complaint, And then the very next day, we had a motion for TRO saying, please freeze the case pending arbitration. And there's one more piece to this that distinguishes Turpin and Educators Mutual from the present case, and that is how this court ought to read the precedent from Central Florida Investors. In Central Florida Investors, the Supreme Court said, although admittedly it was a defendant, but they filed a counterclaim, they filed a motion to dismiss, they waited around for a while, and then they filed their motion to compel arbitration. And the court in Central Florida Investors said, okay, this is a close call, and although your practice was not ideal, we're gonna find you didn't waive because you were largely reactive, unwilling participation in litigation, those prongs. But what we can read from Central Florida Investors is, because there's a strong public policy in favor of arbitration, waiver is not found lightly, and less than ideal procedural practice does not amount to waiver. That's the way to look at.
What should we make of the idea that you didn't file a motion to arbitrate until after learning the outcome on the TRO ultimately? Because you certainly could have filed a motion to arbitrate and then still sought the provisional remedy.
Yeah, so there's two things to take from that, Your Honor. The first is that the record still bears out that during the time that the TRO was pending and we were awaiting the district court's decision on the preliminary injunction and the extension of the TRO, there was still correspondence that's referenced in the record between counsel saying, we want to arbitrate, let's do our ADR. So if we're supposed to look at all the facts, which Chandler says we're supposed to, those are relevant and at least counteract some of the litigation behavior, which may, at least in first blush, seem counterintuitive to a right to litigate, but are still party to party communicating, hey, we're not waiving this. But second,
Should we be able to look at the outcome or merits of the litigation activity? In the end, you lost on the TRO and the Liz Pendens, and there was a whole lot of litigating that went on there that ultimately wasn't fruitful from your side. Should we be able to look at outcome, or just we look at was it a provisional remedy that was being litigated, and not look into the extent that it was then litigated or the outcome?
yeah, that's the first thing, is that it was in fact a provisional remedy which was being litigated in aid of arbitration. So let me pose a counterfactual. Let me say, for example, suppose the Hardman brothers had explicitly said we're citing section 109, we see this as a provisional remedy, and they lost, but it was still explicitly in aid of arbitration. I don't think that would be considered to be waiver activity, because they're still explicitly saying we want this as part of our arbitration suite, let us say. But second, I think what your question is really getting to is not necessarily intent, but is getting more into the second prong of the Chandler test, which is prejudice, and is really speaking more to the concerns in Pledger about forum shopping. But forum shopping, I don't think, is appropriate here to find. Well, for one, the district court didn't find it, didn't say that there was forum shopping. But for two, if you're explicitly seeking a remedy that section 109 says is kosher, for lack of a better term, with an intent, I'll finish my answer and then I notice I'm out of time.
And then I may have one more, I'm sorry.
But if you're specifically seeking a remedy which is coherent with what the statute says, does not constitute waiver, and you don't prevail on that, so you have to win in order not to have waived litigation, that effectively takes away the safe harbor. It makes it into a must-win situation. So I don't think that's a good way to read that statute, but I also don't think it's a good way to read the progeny of Chandler, because that's all about intent, not outcome. So the second prong, forum shopping, is relevant as to prejudice, which part of your Honor's question gets to, but that wasn't found by the court, wasn't considered by the court, and you don't know you're gonna lose when you file the motion. And if you were to say, well, because you lost the motion, you've therefore waived, then the test is, well, did you win your request for provisional remedies, which I think would stand Chandler on its head.
Here's my other question that may take a couple of questions to ask. I understand that the remedy or the action you want from this court is a reversal, and well, are you asking us to tell the lower court to send you to arbitration?
Yes, to remand us to arbitration.
Has there, there's been a fair amount of litigation since this appeal was filed. Am I correct on that?
There's certainly some on the docket. There is a little bit on the record. The brother, or the sisters and parents tried to introduce quite a bit more of that into this case that was not on the record. But yes, the district court did order the brothers to answer a motion for summary judgment, which was pending, to propose a new case management order to basically move forward with the litigation. Now, we suggest that's an error, and, you know, maybe.
So yeah, I guess that my question is, has your side done anything to move the litigation forward that you weren't ordered to do since the appeal was filed?
I would say no, because the order was, now go litigate. And we are the plaintiffs. So if we're the plaintiffs and we're ordered to litigate, and the court has said arbitration's behind you, litigate this course in the normal course, but we still have the burden of prosecution, the burden of moving forward. And that kind of, the sisters and the parents suggest that, well, if you lose arbitration and you continue to litigate, then you therefore waive. It's doubly punitive because we have an immediate statutory right, but we don't have a right to a stay. So we've pursued our right.
Did you move for a stay?
No, we did not. It's discretionary. We frankly viewed it as futile. That it raises an interesting case because in Baker, the Supreme Court did find post-motion litigation to be dispositive. In that case, it was a motion for summary judgment, which was voluntarily filed by the defendants in that case. It was not a reactive motion for summary judgment. But also as distinct in Baker is that the parties in Baker, the defendant who lost the motion to compel arbitration, did not seek an interlocutory appeal as we have done. They said, we'll just wait till the end of the case and then appeal it from the final order. So I think that's where.
You keep calling it an interlocutory appeal. Let's be clear, you're claiming a statutory right
Yes.
to appeal. This is not a Rule 5.
Yes. Forgive the colloquial imprecise language there, Your Honor. I'm in the middle of the case appeal.
Okay.
Thank you.
Any other questions?
No, I'm good.
Thank you. I'll give
Thank
you your
you, Judge
full
Morrison.
rebuttal time. Just so our vast YouTube audience can keep things straight, will you state your appearance again?
Again, good morning. Jonathan Jenkins and Dalton Smewin for the Applees. Donna Campbell and Marcia Jacobs. I think the question in this matter is there a waiver of the right to compel arbitration under the operating agreement found within the parties' LLC? And I think the participation of the brothers in the litigation was to a point to manifest an intent that's inconsistent with arbitration. I think
Can we break that down? First as to timing, and you're gonna have to forgive me if I don't mean to impugn anything if I refer to you. I'm talking about the red briefs collectively, so I may cross-pollinate.
understood.
So maybe it wasn't you. One of the red briefs said, well, there's been, all this time has passed since the filing of the complaint. One of references was like a year and a half. But for our purposes of determining waiver, we look at the time period in between the complaint and the motion to compel arbitration, right? It's 4 months, that's the period, right?
Correct.
So on timing, are you claiming that is indicative of an intent not to arbitrate, 4 months? Is that, and if not, my question is, what would be the time that you would concede still exhibits an intent to arbitrate?
I think timing is an important factor, and I think it's what occurs within that time. In those 4 months, you have TROs, a second TRO, request for preliminary injunction. And as the court knows, in those matters, there in essence is mini trial, if you will, where the court is making evaluations as to the merits of the case.
So are you saying that any time a party files for a TRO, they are exhibiting the opposite of an intent to arbitrate?
I'm saying they think they ought to be particularly careful when they ask for a TRO specifically, what's the remedy they're asking? And I would like to focus on those two issues. We have a complaint that's filed in this case, and then there's a TRO. And I think the appellants.
So before you do that.
Yeah.
Was that a yes or a no to my question? My question was if you file.
No, I think, pardon me, I think there are times, you ought to be careful, and when you do file a TRO, if you do, you need to say, this TRO is filed for the purpose to preserve our rights under the arbitration agreement.
Well, didn't, they referenced the fact that there was an arbitrating agreement on page 2 of their motion for TRO, right?
Well,
And it says the parties request the court enjoin and restrain any further transfers of the parcels pending resolution of the dispute at arbitration. That's
yeah,
what it says, right?
well, it does say that, and I'll concede that, but when I look at the TRO, a couple of things come to my mind. First of all, I think it's the Central Florida case that talks about when we're determining intent, we need to look at not just what's conveyed to the parties, but what's conveyed to the court. And in this case, nothing's conveyed to the parties because they filed a complaint and then subsequently filed a TRO ex parte.
Can we go off on a tangent for half a second here?
You bet.
They're claiming that prior to the filing of the complaint, they sent letters saying we want to arbitrate. True or false?
False, I'm unaware of that.
Okay. They gave me a record number, so I'll
Yeah, I wanted to look
check.
at that, I'm sorry, I'm not
Yeah,
that
no,
quick on the record.
I
Maybe you
don't
can
have
tell
a
me.
record either.
What's the record?
They then claim that on 9 occasions, in between the filing of the complaint and their motion to arbitrate 4 months later, they communicated to the parties that they wanted to arbitrate. True or false?
It's hard to be so binary. I think it's false. I can recall some loose requests, any interest in mediating, but never a point to, hey, we have contractual rights to arbitration in this agreement. And I want to go back to the TRO because I think that's the most primary issue that
I said it was a tangent, so go ahead and go back.
that when the court reads the page, what's the purpose of the order? They're requesting an order to enjoin the defendants from any further transfer of title of the properties. Why? Until a proper and competent valuation of each property owned by the LLC can occur. I read that as part of the reason, but let me go further. Admittedly, there is a line buried in here saying arbitration. Now, I caught it, I didn't catch it, but I wasn't given a copy of this. This was ex parte to the court. But when you look at what the thrust of this TRO is, and that's why I think it's important that we focus on what the scope is, the conclusion is what I think the remedy that's being requested, and it says, this court should grant the injunction and freeze and further transfers of the listed parcels from further sale or conveyance until the parties achieve an equitable outcome or fully, and I believe that's a typo, but it says fully litigate this case. I can't think of anything clearer. Now, when I go to the complaint, which is what the case law seems to focus on, there is no mention of arbitration. In fact, the complaint says jurisdiction is proper in this court, and it concludes in its request, and they're asking for costs and damages that may be determined during the course of this lawsuit. Well, I think those things categorically telegraph there's an intent to litigate. And if that weren't enough, there's a whole raft of litigation that ensues around the TRO proceedings and also the lis pendens.
Can I ask this question?
Go for it.
In your brief, Mr. Jenkins, on page 39, you say, indeed, the brothers have on several occasions made requests that the court enter specific orders and injunctions that are not available remedies in arbitration, such as temp TROs, permanent injunctions, and lis pendens that are only available in litigation. Doesn't that directly contradict what you're arguing today? That if those remedies aren't available in arbitration, what else are they supposed to do?
I think what they're supposed to do is be very upfront saying, we're going to be relying on our arbitration right. it's the case law that seems to indicate, how do we determine what intent is? Well, if they're trying to exercise remedies that aren't available in arbitration, they shouldn't be doing that.
So they can't have a lis pendens.
Well, no, if you look at the lis pendens statute, which is a statutory
Right.
creation, it specifically says in the code, that has to be founded on a complaint. And that
Right,
became.
that's why I'm asking the question. So if I want both to arbitrate my claim and I want a lis pendens, because I want to tell the world, hey, don't get involved in that title, I claim an interest, you're saying I can't do that simultaneously?
I think that's probably why the convention changed and revised the Arbitration Act. So if the new Arbitration Act were applicable, which it isn't, they've crafted around that because they think they found that there was some problems. But I don't.
How exactly do they craft around that?
Well, I think.
You think 109 gets them there?
Yeah, I mean, I think that once you've arbitrated and you're ready to arbitrate, you can go back to the court and get some additional provisions. But I don't think that's a mechanism that a party who intends to arbitrate should be doing. I don't think you should be filing a lis pendens. Why? Because in order for it to not be a wrongful lis pendens, you have to file a complaint that alleges, for example, quiet title. And so if
Would you concede that a lis pendens is a provisional remedy?
I have a hard time answering that question, Judge Lucy. I certainly think so.
Is a TRO a provisional remedy?
No, I don't think so.
Why is that?
I think the elements, let me just craft it this way. I think that they could possibly be characterized as provisional remedies for the lis pendens, but I think both of those remedies require invoking the jurisdiction of the court and filing of complaints for specific causes of action. For example, the lis pendens, I need to allege quiet title in the district court.
Well, this was why I asked the question to your opposing counsel. If the code allows you to initiate arbitration, which they're saying they did with a letter, and then go to the court for provisional remedies, I'm not sure that we then ought to be evaluating the waiver of arbitration based on whether your provisional request for a provisional remedy ended up being granted or had merit. Because then we're, on this appeal, reviewing the merits of a motion or a request for TRO or lis pendens that is not before us. We'd be doing a merits review to determine whether arbitration is appropriate. And I'm not sure that that's the position we're in. Seems like if it is a provisional remedy and you're allowed to seek provisional remedies, then we don't need to look at whether you were alleging quiet title and doing a lis pendens. It's probably the better way to go. But we would look at, did you initiate arbitration and then seek provisional remedies? And then we don't look at what happened as you sought provisional remedies, but the code would allow you to do that. How is that wrong? And part of it, I know you might say, well, that's wrong because this version of the statute doesn't apply, but let's assume that this version does.
I just think they have it exactly backwards. I think the provisional remedies of the statute is you invoke the arbitration. There's no question by either party, hey, we're in arbitration, and I think it has provisions that talk about, okay, once that's clear, and we're even willing to go so far as prior to selecting the arbitrator, we can get the court to get provisional remedies, but you certainly cannot go and as the Chandler factors talk about, you certainly can't go, invoke the court's jurisdiction, begin to litigate, decide that the case isn't going well, and then hit it in reverse, go arbitrate and say, those were just provisional remedies.
Maybe you can't do that, but Chandler clearly says, who wrote Chandler? Let's see. Chief Justice Hall, fairly bright individual. If he wanted to write a rule that says, if you file a complaint, you're done. That's just inconsistent with arbitration. But that's not what he wrote in Chandler, was it? You can file a complaint and not waive your right to arbitration. True or false?
Well, I think later if I've got the dates right, yeah, it is later. Educators Mutual comes out and says, hey, if you file a complaint, it's pretty well a foregone conclusion there's an intent to litigate. Now, when you read these complaints, it's very clear there's an intent to
So you
litigate.
think the current rule in Utah law is that if you file a complaint, I mean, maybe your brief should have been shorter. If you're saying, if you file a complaint, you're just done?
Well, there's a two-part analysis, right? But in terms of the first prong, largely, yes. The second analysis is prejudice, but certainly, I think so. When you initiate the litigation, I mean, the only thing close to this case is the Central Florida, but what they did is they made it clear in their affirmative defenses, hey, we want to arbitrate, and then they filed a counterclaim, and the court said,
And then they waited 4 months
gosh.
to file the exact same
Yeah,
period as this
you're-
case,
You're
right?
awfully close, but we have additional factors that just clearly push it over the edge. And so on that basis, we would ask that the court
Well,
affirm.
see, that's not the question I'm asking though, because when you say that it has additional factors, then that's what we get into, is whether, under the Chandler analysis, whether there was an intent. But to me, that's apples and oranges from a rule that just says if you file a complaint, you have shown an intent to litigate, period, regardless of any additional factors.
Well, I only say that, Judge Morrison, because there's two factors. In terms of the first factor, I think
Right.
it is met.
Okay,
But the second
Then you have to
factor,
show prejudice.
You still have to argue.
okay.
I'm still hoping for more on which version of the act applies, and I'm okay to hear that from you or from your co-counsel.
I will
Or
just,
maybe both.
I'll say it in simple terms. My co-counsel is, from Hilliard Anderson, is going to argue specifically those provisional
Then
remedies.
I'd be happy to hear it from him.
We can hear it from him.
Thank you.
Your honors, may it please the court, I'm Drew Parkinson, and I represent Appalese Heber and Shirley Hardman, though I will point out, I don't think this was mentioned before, that Heber Hardman has passed away earlier this year. I will still refer to them as the parents, just for ease of reference. From our perspective, the real issue before the court is really the Chandler test and whether the district court properly applied that test to the facts of this case. As mentioned before, there's really two factors for that test that are at issue here. Whether the parties substantially participated in litigation such that they demonstrated an intent to submit to the jurisdiction of the court, and then two, whether the responding parties had prejudice or incurred prejudice. I will point out first and foremost that throughout the appellant's brief, they refer to the prejudice prong as requiring substantial prejudice, and I don't think that that's a correct recitation of the standard. The substantial portion of the Chandler prong in the subsequent case law dealing with that test states that there has to be substantial participation in litigation. Then, semicolon and, there just has to be prejudice that's shown against the parties. So it's not as an exacting standard as the appellants are making that out to be. Replete throughout their brief, it does mention that there's substantial prejudice. So,
When we talk about the first factor,
sure,
some of the cases talk about, well, Chandler at least says there's a presumption. The reason you need to show intent to arbitrate is because if there is an underlying arbitration agreement, there's a presumption against waiver. Here in 2023, do you think that's the current state of the law, that there's a presumption against waiver?
yes, I do. I think that that's an accurate recitation of the case law. But that presumption is rebutted by, again, those two factors, substantial participation in litigation and prejudice to the other party. While the general rule is that there is an idea that it should not be waived, it does not mean that it cannot. As a matter of fact, specifically in the statutes, I think that it addresses that really clearly. If we're looking at specifically the new section, or the new statute that appellants argue applies versus the old, the equitable argument is essentially the same. So in the new statute in section 107, there is an exception that says, except upon a ground that exists in law or equity for the revocation of contract. That same provision makes its appearance in the old act, the 1996 Act, in section 3. It says, except upon the grounds existing at law or equity to set aside the agreement. So there are exceptions to the rule. The exceptions are the Chandler test, whether they participated in litigation and whether or not there was prejudice. The district court very clearly found that that happened here. And it was not exclusive to the filing of a complaint, the filing of a TRO. There were actual several factors that the district court found weighed in favor of that substantial participation and prejudice. If we're looking at the record, specifically on pages 1153 and 1154, the court recognized that the appellants had filed a complaint. They filed a motion for a temporary restraining order. They filed a motion to extend the temporary restraining order. They filed 32 lis pendens. They filed answers to counterclaims. They participated in fact discovery. They issued initial disclosures, and they engaged in other motion
What
practice.
fact discovery besides initial disclosure, well, assuming for a moment that initial disclosures are fact discovery, but what besides that did they do between the complaint and the motion to compel arbitration? Did they take depositions?
If I recall correctly, the appellees, the sisters filed requests for discovery.
No, I'm
discovery
asking
requests.
what the plaintiffs did
They would respond, they responded to that.
to request for admission.
Mm-hmm. Yes. So it
So
wasn't.
you think if they had an intent to arbitrate, they should blow off requests for admissions? That seems a pretty weighty bet.
Well, I think you kind of have to think of this in two different ways. You have a provision in the operating agreement that is extremely clear that the parties do not agree to litigate. And if you look specifically in our brief, of course, the operating agreement provision is there, but it says no civil action should be taken. The statutes at play here essentially state that you can seek remedies over here in the district court if you first filed a motion or a motion to compel arbitration or a complaint in arbitration or a request to arbitrate over here. So I think they're kind of two separate things. Once you have entered the forum over here, you kind of have to play by the rules. By filing a complaint in litigation, they have an intent to participate in that litigation instead of arbitration. Here, they didn't file a complaint in arbitration. I do not recall a formal letter request for arbitration at all. I recall some emails vaguely requesting that the parties mediate or work things out, but there was no formal request for arbitration. And that's not in the record. The citations that counsel has pointed to for backing that up are just a motion saying, we did this. That's what essentially the record states. So there is no evidence in the record that that was actually a formal request for arbitration.
I have a question.
Yes.
Your brief at 36 gives a list of things that the brothers did. Some of those, I think, are provisional remedies, the lis pendens and that. But you get further down on your list and you talk about a statement of discovery issues, a proposed amended complaint, separate counter summary judgment motion, leave to file the amended complaint. I presume those happened after they filed their motion to arbitrate?
Yes, but before they had been ruled on or argued.
And that's my question, is the relevant time period the 4 months between filing the complaint and the motion to arbitrate? Or can we look past the time the motion to arbitrate was filed?
I think you can do both. So I think initially with the district court, they did consider that 4-month time period as the initial, you guys have waived arbitration. But that does not preclude this court from looking at it retroactively and saying, okay, what happened after that? That's what that Baker v. Stevens case talks about specifically, is what happened after that the parties, or that then demonstrates the parties, again, waived arbitration. So I would submit that they've actually done that twice.
So the things that I just listed, the statement of discovery issues, proposed amended complaint, and I guess I should know this, but I don't. Did those happen after the notice of appeal as
Uh,
well? Or did they happen before the appeal?
They happened before. So since that time, and obviously this is in the docket, in the lower court, they have moved to amend the complaint 7 times. Interestingly, and kind of as in response to that question, they, appellants did file a motion to stay this case pending appeal about 10 months after they filed the notice of appeal. So they went through all of the litigation machinery, and things that aren't mentioned in my brief that have occurred since that time are depositions, subpoenas.
Before they filed a motion to stay?
Yes,
And so that goes to kind of the question I had about if we were to rule against you and say that the trial court got it wrong, do we send it back for arbitration, or do we send it back without prejudice to a new ruling on arbitration in light of what's happened since?
at the most, I would remand it for just further findings, because I think that would be the only thing that would be missing here. A full remand would largely go against public policy, because they would have been allowed to litigate a case to trial, which is essentially where we're at. We don't have any other litigation activities left, it's trial. So that would be a remand with almost 3 years worth of litigation that would essentially be reset. That's what the Baker v. Stevens case is essentially saying. You can't have both. You can't have 2 bites at the same apple kind of approach. You either arbitrate it or you don't.
We didn't get yet to my question at the end of your co-counsel's argument.
I'm happy to answer them.
Please do. Which version of the statute and why?
The old version applies, the 1996. Or the one that was in place when the operating agreement was entered into. And I'll explain why. So the statutes themselves are very, very clear as to what retroactive ability it does have. So the cases relied on by counsel for the appellants essentially rely on a very, very uncommon exception to the rule for procedural statutes. I want to point out that the Beaver
Maybe
County.
before you go further, let me, and I'm sorry to jump in on you.
Sure.
I think there's an implication that I have in mind that I ought to say as you answer, that if the current statute applies, it lays out a framework for how you're supposed to do this, to seek provisional remedies and still preserve your right to arbitrate.
Correct.
And that is to file, or to, the current section 107 says, and I've moved, and essentially it says you send written notice to the other side that you want to arbitrate, and that initiates arbitration, and then you can seek provisional remedies.
Correct.
If it's your position that they never initiated arbitration, it seems like your argument may be better under the current code, that, look, we have a framework under the current code to do this. You didn't follow that framework, and it was right in front of you. And so, knowing that, I wonder if that's not a possible answer, which version of the code applies and why, and what's the implication?
I do think the 1996 applies, but I don't think that it actually matters which applies. The reason is because the Chandler test is an equitable remedy or an equitable result that's contemplated by both statutes that allows a waiver to essentially get around those provisional remedies. So you're absolutely correct. In that section 109 of the new statute, it says before an arbitrator is appointed and authorized and able to act, the court may enter and order provisional remedies. But the specific part here is that the party has to be party to an arbitration proceeding before that remedy applies. That isn't the case here. So you're correct. Procedurally, I think they've missed the boat on that. Now,
But if you're right that the prior statute applies, do you have a case that says that you can't seek provisional remedies under the prior statute?
the statute itself doesn't allow provisional remedies.
But does that mean that it bars them? Or do you have a case saying that it bars them?
No, I don't. I'm not aware of one, Your Honor. But I think that when you're looking throughout the whole corpus of precedent here, that simply does not happen. when we're dealing specifically with these provisional remedies, I think that's why council goes towards these procedural arguments, is because there really hasn't been an issue that has addressed that specific question before.
Any other questions?
I'm good, thank you.
All right.
Okay, well, we would ask that the court affirm the district court. Thank you.
Very good. Turn to rebuttal.
Thank you, Your Honor. In the nature of this type of argument, I'll try not to be too disorganized and a little more put together. But I think the first thing I want to point out is that there was an argument raised about the standard for determining prejudice, and that it's not substantial prejudice, but the standard is substantial participation. Now, if you read Turpin and you read some of the other case law construing prejudice, whether they say exactly the standard is substantial prejudice or not, they say you have to have more than theoretical prejudice. So if you're claiming that some type of litigation activity may affect me, you've got to prove it up. And they're also saying that if you've been prejudiced to the extent you were forced to incur fees or expenses to litigate things which you oughtn't to have been litigated, you've got to prove that as well. And that was frankly a surprise to me because I was on the receiving end of that ruling in Turpin, and the case law hadn't said that until then, but it says that now. And it's undisputed that there hasn't been any documentary evidence presented substantiating the prejudice in terms of that second prong of the Chandler test. So to some degree, one of the easiest ways to resolve this case may simply be to say district court's opinion failed to follow the standard articulated in Chandler and its progeny with respect to what constitutes prejudice. The other thing I think that we need to look at, it was suggested that if we were to do a full remand, if this court were to order a full remand and say go straight back to arbitration, that would be contra public policy because there's been something to the effect of 3 years of litigation to the point of culmination of the lawsuit. Maybe, maybe not. That relies on a lot of facts outside of the record to reach to that point. But then it would also have been against the brothers' intention. The district court ordered them to litigate. They don't get to say no to a judge. We have, I could quote Thurston or whatever the rule of decision is. I forget the exact terminology, but it basically says you follow the orders that the courts give you. And you appeal at the final order if you don't have a provision, a statutory or an interlocutory remedy. So
Are we correct, though, that that partial list that I read from, that after the motion to arbitrate was filed, but before the appeal was filed, that in that window there was, from your side, a statement of discovery issues, a counter summary judgment motion, leave to file an amended complaint? Did those things happen before the appeal?
I don't recall all the specifics. What I do recall, Your Honor, is that the complaint's filed sometime in September. The motion to compel arbitration's filed in, I think, November. That's not decided until, it may have been April or it may have been August of the following year. And then within 30 days of the statutory period, the appeal was filed. Now, in the interim, there were discovery requests served, to which the brothers responded by moving the court to stay their obligations to respond to the request for admission. There was also a motion for summary judgment filed, to which the brothers responded by saying, stay our time to oppose until the court has decided the motion to compel arbitration. So there were, in the litigation, there were interim steps guided at, Judge, please decide the arbitration issue first, or at least
Before
don't make us.
anything else?
Yeah.
Okay.
Unless there are any further questions from the court, then we're happy to submit our arguments on the briefs and ask that the court reverse and remand. Thank you, Your Honors.
We appreciate your arguments today and your briefing, and we'll take this matter under advisement and issue a written decision in our regular course. Thank you for being here today.
Thank you.
This court is now in recess until 3 p.m.